This Honorable Court of Appeals of Tennessee is now in session.
On behalf of Judge Stafford and Judge Golden, we are pleased to welcome Mr. Burke and Mr. Henry for oral argument on this case, which is being live streamed for the benefit of the public. And of course, it is also being recorded and will be uploaded on the court website for reference by the parties and the public in the future. We will conduct the argument in the same fashion as if we were all together in the courtroom. Each side has 15 minutes, and the appellant has already reserved some of his time for rebuttal. So unless there are any announcements, I will ask Ms. Lindsay to call the case.
Sylvia Davis versus Keith Monuments.
Thank you. And Mr. Burke, you have the floor.
Thank you, Your Honors. May it please the court, I'm Ronnie Burke from the Hamilton County Bar, and I represent the plaintiff in this action in which the trial judge granted a summary judgment. Just briefly with regard to some of the facts in this case, Keith Monuments delivered and installed a monument, a gravestone, in this case in 2014. Just 2 years later, the gravestone fell over and broke my client's hand while she was setting some flowers, not on the monument itself, but on the base of the gravestone. When we took the installer's deposition, the installer said that he didn't know what type of adhesive or setting compound was used to attach the gravestone to the base. But when we sent a request for production of documents, we asked for all of the invoices for setting compounds from 2010 to date. And the only invoice that they sent us was for putty. And that's important because the installer did say that they had been using the same adhesive for at least 10 years or more. One other very important fact is that it was only the gravestone that fell. It was not the gravestone from the base. In other words, the gravestone or monument became detached from the base. And in this case, we filed two affidavits, the second one being the most important one, of Manny Rico. And Mr. Rico has been in the monument business for about 50 years. This is all in his affidavit. He's done everything from selling monuments to installing monuments. He owned and ran a monument business for 34 years. He's familiar with the products used to attach a gravestone to the base. He's also familiar with the proper installation methods of attaching a gravestone to the base. And he also stated that he knows the results of what happens if you use either the improper adhesive or even if you use the corrected adhesive, improperly attaching the gravestone to the base. For the facts that he used, it's set out in his supplemental affidavit in paragraph 4. All of the facts that he considered were in the undisputed statement of facts with citations to the record or depositions or request to admit or request for production of documents, so that everything that he used to get his opinion is in his record. His opinion was that, number one, that putty was an improper adhesive to use. He also said that even if you did use a proper adhesive, in this case, it would not have been applied properly. He noted that if it was done properly, the monument should have stayed attached to the base for at least 40 years or more. and that it was probably be almost permanent. We all know from our common experiences that we go to graveyards for funerals and to visit the deceased, and we don't see gravestones falling over all the time. So I think that his affidavit is not only within his expertise, but it's also something that we see in everyday life. He said that since the monument fell, it has to be one of two things. Either they used the wrong adhesive, and certainly putty is improper adhesive, or even if they did use a proper adhesive, that it would have been applied improperly. He said that this was foreseeable and that these would have been the proximate cause. He said that if you use the proper adhesive and apply it properly, that if the monument had fallen, it would have stayed attached to the base and the base would have come up out of the ground. In this case, the facts are that the monument fell, became unattached to the base because the base stayed in the ground. And he said that that means that it was installed improperly. The defendant did not put on any expert, did not put on any employee or anyone to refute Mr. Rico's opinions. The trial court in deciding this matter, I think, made several errors. Number one, the court speculated and said there could have been other things that may have caused the monument to fall. He speculated that lawnmowers may have hit it, people may have hit it. There are a lot of problems with that. Number one, none of that's in the record. There's no proof that any of those things happened. Number two, even if they did happen, that would be in the vein of an affirmative defense. And it would be up to the defendant, and the burden of proof would be on the defendant to show that one of those things happened. Because once we have shown that they were negligent and their negligence was foreseeable, their negligence was the proximate cause of the gravestone falling and breaking my client's hand, then any affirmative defense that the defense wants to raise, the burden would be on them. Secondly, the trial court treated my case as if it were a res ipsa case, which it's not. We didn't plead res ipsa. We don't think it's a res ipsa case. And it's not a res ipsa case because the defendant did not have control of the situation at the time. We proved negligence. We are not approaching this and never have approached it as a res ipsa case.
Mr. Burke, let me ask you a question. I know there was an objection raised by the defendant as to the supplemental affidavit, saying that it was not timely filed. Apparently, it was filed 3 days prior to the hearing. Did the defendant request an opportunity to respond to the affidavit or any additional time, or did it indicate in any way that they were prejudiced could be prejudiced by the affidavit by not having time to respond or anything of that nature?
No, as a matter of fact, I think an important point is that this was not our initial response. We filed our initial response to the motion for summary judgment with other affidavits and other undisputed statements of fact long before the hearing. What happened is that Mr. Henry filed a response not only to our undisputed statements of fact, but also a memorandum response. We filed our supplemental affidavit 3 days after Mr. Henry filed, which I think is pretty quick. And so it was really in response to what he had said in his response to what we had filed. And so we think that that was proper. I offered at the hearing that if he thought that there was a problem, that I had no objection to him continuing it to make any further responses that he wanted. But he elected to go ahead and go forward.
Did he indicate any desire to file any response to the affidavit, to file his own affidavit or anything of that nature?
Not that I know of.
All right, thank you.
The trial court said that and I think this is wrong too, the trial court said that the defendant is not responsible for all reasonably probable causes. Now, we, through our expert, proved what we thought was the cause. None of these other causes, again, were in the record. The court was saying there are all sorts of things that, quote, could have happened. But none of those things were in the record. And again, it would be on the defendant to prove that those things are what caused it to fall. The burden didn't shift according to our trial judge. I don't think that the trial judge could have gotten into those things because none of the things that he cited that were probable or possible causes were in the undisputed statements of fact of either party. The plaintiff's expert opinion showed that there was negligence, that it was foreseeable, and that there was proximate cause. And again, this monument should have stayed attached to the base for at least 40 years, according to our expert, if they used a proper adhesive and it was applied properly. It did not last 40 years. It just lasted at the most 2 years. So we think the court is in error. We would ask that this case be tried on the merits. Thank you.
Thank you, Mr. Burke. We'll now hear from Mr. Henry.
Good afternoon, Your Honors. If it may please the court, Al Henry of the law firm of Luther Anderson in Chattanooga on behalf of the defendant Keith Monuments. A little bit of additional background before I address the primary argument of the plaintiff on this particular case as it relates to their expert affidavit. The fact is that this case had been pending many, many years. This was the current case was actually refiled. There was an original lawsuit filed back in 2017 where the plaintiff sued both Keith Monument and the company Highland Cemetery where this plot was located. This was Highland Cemetery was dismissed via summary judgment. The plaintiff non-suited and then refiled this case in May of 2019. During previous discovery and current discovery, no factual information was ever provided to explain anything surrounding this unexpected monument that fell. Indeed, the plaintiff and agree in undisputed fact that there was absolutely no indication at any time of any problems with the headstone or that it had fallen or on our prior visits. The plaintiff also was not a party to the contract as it relates to this particular monument. The allegations that were made in the case included that we manufactured the monument, which we did not, which was an undisputed fact that was later agreed to. Further, that it was not on any location or premises that we had any control over for the excess of 2 years after its installation. In fact, my client has also indicated, which is also undisputed, that nothing like this has ever occurred. As it relates to plaintiff's only response on this after this case had been pending many years, after it had been refiled again, was at the last minute, the plaintiff submitted originally an affidavit of Mr. Rico that was dated April the 13th, 2020. That affidavit was grossly inadequate. And as a result of that, we filed a motion to strike that affidavit. The supplemental affidavit, in spite of the fact that this case originally started and originally filed in 2017, was made improperly and only in response to attempt to repair the grossly inadequate affidavit on the first time around. And that's why it was scrambled and filed at the last minute, which we strenuously objected to.
Henry, I don't really want to interrupt your argument, but
Yes, sir.
you're spending an awful lot of time of talking about delays and inadequate documents in the past. I'm here to consider what was presented to the trial judge, and that last affidavit is what was presented to the trial judge. So I'd like to hear from you what's deficient about that last affidavit.
In terms of that last affidavit, first of all, in terms of it was only provided 3 days before the hearing of the date of the argument, in violation of the rules. It's supposed to be 5 days before. It was not. We voiced that additional objection to the supplement in terms of that. Now, in terms of the supplemental affidavit that was drafted, first of all, Mr. Rico, throughout the first and the second, bases his opinions on using the term or referring to something as putty. We had submitted the affidavits of the actual individual that was involved with installation, Mr. Charles McGee, also deposition testimony that supported and stated that he used setting compound. He could not specify the details of the setting compound used. And of course, there has never been any prior problems. Mr. Rico.
Why couldn't your client provide a financial record showing that it had purchased the setting compound?
Your Honor, the person that was operating the monument company at the time of this installation was a Mr. Keith, who died. After Mr. Keith died, also his brother that assisted him in the business died. At the time of this litigation ensued, it was his widow that had taken over the business, who had not previously worked in the business. In terms of asking about what, this is many years later, about what records they had, about what they purchased for an installation in 2014, she did not have any records about what had.
Aren't you supposed to maintain financial records for IRS audits for at least 7 years?
Your Honor,
and it's just now 7 years today.
Your Honor, in terms of the previous, the remaining widow that took over the business did not try to locate to the extent of what records or information she had on what had previously been purchased. She was not able.
Why didn't she? She has an obligation. If discovery is submitted to a party, they have an obligation to search.
She did search, Your Honor.
Just say, I don't know.
No, the response was never, I don't know. The response was that she was unable to locate and trying to find records from her deceased husband years after this occurred about what was purchased, what specific was purchased prior to the 2014 installation.
Well, you say records of her deceased husband. We're talking about a business records.
Well, actually, the business entity had changed. At the time, it was basically a sole proprietorship, actually, in 2014. It is, at the time of this lawsuit, it actually had been changed by her and set up as Keith Monuments, LLC.
Well, it's still a business. It's still a business. You don't throw the records out.
Your Honor, she wasn't involved in the business at the time. She wasn't involved in the business. She did not have control.
Can't be found. Isn't there that a spoliation problem?
Well, Your Honor, there is no evidence whatsoever in terms of that anyone at any time lost or tried to destroy or get rid of any records. This was multiple years later after it. In fact, the only source of this, and I believe the plaintiffs also attempted to contact the source of the setting compound, which was Avery Monument, which actually is the same supplier of products to his expert for what records that they had, and they didn't have any either. That we produced the only thing that my client, which is now is operating a different business, which is Keith Monuments LLC. She was not operating the prior business. So first of all, in terms of spoliation, she was not, the business she operates as LLC. She didn't have the record. She searched for it. The only record that she had was something more recent that she had, which was from Avery Monument, who actually manufactured the product.
And the suppliers of Keith Monuments couldn't find any record of setting compounds. to Keith Monuments. Is that right?
Yes, Your Honor. At one point in time, Mr. Burke was intending on actually taking discovery as to the owner of Avery Monuments and then decided not to.
Mr. Henry, the document that was provided by your client from Avery Monument shows one bucket of putty, and then the statement was made by Mr. McGee that they've used the same setting compound for the last 10 years. I'm gathering that if you're that the document that was provided shows that this is what y'all said was what was used, what you've been using for the past 10 years, and it's described from Avery Compounds as one bucket of putty. That's what the invoice says.
That's not what Mr. McGee was questioned about. This was a subsequent document request that was actually made after the depositions, not at the time. Mr. McGee had referred generally to the product that they were using in the past was basically, to his knowledge, the same product. This discovery request was sent after. No one ever questioned him about this invoice in 2019, whether or not it's the same product. And then, of course, the whole basis of Mr. Rico's affidavit, which he indicates that putty was used at the time. There was nothing in the affidavit or Mr. McGee's testimony about putty being used. Further, there's never been any information provided that Mr. Rico has any forensic information or experience. The fact is that my client was not even notified that this had fallen over until approximately February of 2017, and some unknown person had already repaired it.
Is this the only document that your client provided from Avery Monuments, which is the document that indicates that it was one bucket of putty? Is that
yes, Your Honor. The business had almost actually ceased operation after the deaths of my client's spouse, and she hadn't run it in the time. And this was something more recent, and again, it was produced afterwards. In terms of Mr. Rico, there's never any foundation that's ever been supplied in expert discovery or in his affidavit to indicate, first of all, that he has any background or basis in science, with the judge being the gatekeeper, as to how he can determine that but for the proximate and or legal cause of the failure of this monument, if he's ever done any inspection on the failure of this monument. What are the properties of what he believes was used as opposed to what he's guessing was used otherwise? He then gives an opinion that, well, if it failed, they must not have used enough. Well, what is the basis? What is enough? What is the science that the court can evaluate this quote unquote expert to determine about what the standard is? He never sets any standard. He never sets any experience for standard about what the components of the particular products are, while one is proper and why one is improper. He merely makes a conclusion. He doesn't cite that there is any recognized expertise that anyone can look at in terms of peer-reviewed studies or recognized in that profession, or that any of his opinions are based upon a reasonable degree of any type of certainty. But he merely makes conclusions on facts he does not have. Nobody ever inspected this monument. My client never had the opportunity to hire or have anybody look at this monument because it had been repaired before they were put on notice. So Mr. Rico, in terms of, cannot basically, just because he was in the business, there's no foundation laid in either of these affidavits, either the one that's timely or untimely, that there is any recognized standard in the industry. He's just giving his conclusionary opinions. He doesn't cite to facts as to why, what is putty? What are the components of putty? What are the comparisons that he made? What is the standards as in terms of what is too much or not enough? And what are the facts on which he makes the assumption that, well, if they didn't do this, if they used the proper material, which again cites and underscores the pure speculation of it. If he doesn't use the proper material, then they must not have used enough. He doesn't cite to any fact in that regard on this. This has been out of our control for many years with nobody ever looking at it at any point in time to examine it or determine what happened. We don't know whether or not, in terms over the many years about out of our possession, and including that this is the basis of them suing Highland Cemetery, about whether it had been damaged, weakened. We don't know whether or not the actual monument itself was defective. Again, they're suing us also as a manufacturer, which they acknowledge we are not, whether there's defective compound, whether there's a defective monument. None of this is examined in terms of this or any standards set out by Mr. Rico. He basically then just says, well, I expect that it's going to last 40 years. He cites to no authority on that. And that the only way that it can fall is if the installer did something wrong. He doesn't cite to any authority other than just he thinks that's what it should be in terms of also, causation. He doesn't and can't address the issues on his affidavit and does not as to what is the proximate or legal but for cause, but for something deficient in the installation that this would fail. The fact is that we negated an essential element with essential when direct and admissible evidence by the installer, by the admissions of the plaintiff, and indeed of some many requests for admissions that were served on the plaintiff in this particular case, some 23. Only 2 of them the plaintiffs did not admit to. And it's in this particular instance that the trial judge correctly addressed and did not consider in terms of Mr. Rico's information being sufficient to overcome the factual evidence that it was there. The judge being the appropriate role as the gatekeeper did address the fact that this information is pure speculation that has been admitted. It's not expert testimony. There's no foundation for it. There was no disclosure for it in that regard. We had no reasonable expectation based on what was presented at the last minute that there was anything additional that there was to be consider besides our motion to eliminate Mr. Rico, including the one that's not timely. And further, the court also, in terms of the RIL argument, specifically indicated that based on what has been presented, it is really, it notes that there wasn't a specific res ipsa argument, but in fact, it appeared to be what the plaintiffs were trying to argue, that somehow—
Mr. Henry, your time is up. I'm sorry.
I understand.
All right, Mr. Burke.
Thank you, Your Honor. Contrary to what Mr. Henry said, page 169 of the technical record is our request for production of documents that were submitted to them. And we submitted those because the installer knew that they'd used the same setting compound for more than 10 years, but could not tell me what it was and was very evasive. We therefore, in 2020, sent this request for production and asked not for petty. We asked for any and all invoices for any setting compounds purchased by Keith Monuments from the year 2010 until the present date. The only invoice that we got was not something that was way back when this lady wasn't running the company. And this is an extremely well-educated woman that is running the company now. And the invoice was dated June 18, 2019. So this is not some invoice that she found from the distant past. This was an invoice that they had received while this litigation is pending. And the invoice was for 1 bucket of putty. I don't know how much clearer it can be. Mr. Rico went further, even if they were using the proper compound. Mr. Rico, who said that he's familiar with the compounds and the effect of different compounds, setting compounds being used, he also said in his affidavit that he was familiar with the proper installation techniques, and what would happen if the proper installation techniques were not used. He said that even if they had used the proper setting compound, that if they had applied it properly, this monument would have been attached to the base for at least 40 years and almost a permanent installation.
Mr. Burke, when you took the deposition of the installer of the monument, did you ask him to identify the type of settling compound he had used instead of
Yes,
just
I
saying
did.
a settling compound?
Yes, Your Honor, I did ask that, and because we couldn't get the answer to that is the reason that after his deposition, I filed this request for production of documents.
So he said, we always use a settling compound. We always use the same one, but I don't know what it is.
Yes, sir. And
He actually said that they've been using the same one for 10 years, didn't he say that?
yes, Your Honor.
And he didn't know what it was.
And he didn't know what it was, and that's why we issued the request for production of documents so that we could find out what it was. Mr. Henry said that that there was no expert discovery. Well, Mr. Henry never asked to do any expert discovery. There was never any expert discovery interrogatories to Mr. Rico. There was never any expert deposition request taken for him. And, you know, the interesting thing, and the judge did know this because the case was in his court, where the judge talks about, you know, the cemetery could have run a lawnmower and hit it or something. Mr. Henry is the one that represented the cemetery in the first case before we took the non-suit. It would have been very easy of him to adduce some of that as proof if in fact that had happened. We didn't hear it. We asked this case to be decided on the merits.
Thank you, Mr. Burke, and thank you, Mr. Henry, for your arguments. We will take this matter under advisement.
Thank you, Your Honor.
Thank you, Your Honors.
You need to unmute, Ms. Lindsay.
Thank you, Judge. This Honorable Court of Appeals is now in recess until 2:30.
Thank you, Ms. Lindsay, and counsel, you may exit the meeting.
Thank you.
Thank you.